Welcome back. John Whatley with Stein Whatley Astorino, Louisville's personal injury law firm. Today we've got my partner Matt Stein to my right, and we're going to be discussing can I recover compensation after a slip and fall at a business or a store in Kentucky? First of all, I'm going to ask Matt, what are the requirements, Kentucky law requirements for business owners?
For their property, business owners have a basic duty to keep the property in a reasonably safe condition. That doesn't mean it has to be perfect condition, but reasonably safe, meaning they have the obligation to, go out into the store, into the aisles, and make sure that the aisles are clean and relatively safe, that there's nothing, laying on the floor, or that the floor itself isn't cracked or rotted or has any defects to it. So they have to actively go out and look for hazardous conditions in their store. And if they find a hazardous condition, they have to either remedy that condition or at least give the patrons a warning, like putting up a sign, slippery floor, or rope it off, something like that, put a cone, just to alert the patrons of the store and the customers that, hey, there's something wrong with either the floor, or could be not just the floor. If you've got some furniture in the store that you use for the customers, just anything and anywhere that a customer is expected to go, anywhere inside the store or out on the outer premises. The store has to go out, or the business owner has to go and look for dangerous conditions, and that could be a variety of things, not just a hole in the sidewalk. It could be all kinds of things.
Matt, you've been doing this over 30 years.
Yeah.
Can you give the viewer maybe a couple examples of cases that you remember that you've dealt with?
Yeah. Cases with, holes in the concrete, or raised edges that are, unreasonable. And again, that's a sliding scale. What is reasonable versus unreasonable? There's no set standard. It's just if, let's say, you've got a rise in the elevation of the floor or the sidewalk or a driveway or something that, this probably not so much, although that's, could catch the toe of your shoe and cause you to lose your balance. But once you start, the more you go, the more unreasonable it becomes.
Right.
And so if you've got a difference in floor elevations, from here to there, if it's that kind of difference, then yeah, that's unreasonable.
Right.
Because what makes it unreasonable, for instance, if you're a customer and all you're doing is walking around the store with your head down and looking for hazards,
Well,
because the law does require a person to, watch where you're going to a certain extent. But, if you're a store owner, you don't want people walking around your store looking at the floor.
right.
You want them, you expect people to come into your store. If it's a retail
Like looking
type
at the
of store,
merchandise.
yeah, looking at the merchandise,
Right.
looking at the groceries, looking for what they came to the store for. So you have to expect, as the store owner, that people aren't going to be walking around your store with their head down.
Right, it's foreseeable that they may be looking at other items in the store other than directly below it.
Yeah.
And there's a certain expectation that people are able to have that a floor is going to be clear of these types of dangers.
Exactly. Whether it's a difference in the elevation of the floor, or if something fell off the shelves and was laying in the walkway, the aisleway, that can also be a hazardous condition. But then you get into a lot of the details. Let's say there was something that fell off the shelf, or who knows how it got on the floor. The law does also recognize that whatever that item is that fell on the floor, or whether it was, a puddle of lemonade or something, you have to give the retail establishment or the store owner a reasonable amount of time to discover the problem,
Right.
and either remedy it or warn people about it. Because, there are situations where, something falls off the aisle, or a little kid's walking down the aisle and spills his drink.
Right.
And you might have been right behind that little kid, and slipped and fell and got hurt. Well, the store owner really didn't have any time to discover that problem,
Right.
and remedy it.
But there's an exception to that, and that's if the store owner or one of their employees or agents created the problem.
Exactly. So if it's created by some unknown third party, that's one thing. But if it's a dangerous condition created by the store or an employee of the store, then they have to own that problem.
Right.
Yeah.
Matt, for the benefit of the viewer, can you tell us what are the elements that are necessary in order to have a successful premises liability or slip and fall claim in the state of Kentucky?
Well, first, it depends on where you slipped or tripped and fell. And what I mean by that is, who is the potential defendant? Is it a store? Is it a retail establishment versus a friend?
Right.
Let's say
Homeowner.
the homeowner.
Get together.
Yeah, having a get together. You just having a cookout. The law looks at those two situations. Having you're at a friend's house versus going shopping. Okay, those are two different standards involved. So the standard is not as strict on the the homeowner who's having a family get together, or just inviting people over for a cookout. The duty of the homeowner in that situation isn't to go out and search the property for dangerous conditions and remedy them. It's much less than that. It's, well, do you know of any dangerous conditions that somebody that you've invited onto your property might encounter?
Right.
And if you know those dangerous conditions, then you have to give a reasonable warning.
Right.
That's all. I mean, that's still a standard,
Sure.
and it can be violated, in a variety of different ways. But it doesn't require the homeowner to go and look for every single detailed, or to look for every single hazardous condition on the property, to remedy it, or to warn people about it. You don't have that strict of a standard.
But in a commercial sense, a business owner or landowner that's has business open to the public, they have a much higher standard.
Yeah, they have to be more diligent. They have to understand that they've invited people. That's what's called a business invitee. A business invitee is the standard of care for the business owner is higher. They have to do more.
Right.
Because you're inviting people onto your property as a business owner to conduct business and to, hopefully exchange money
Right.
for your services or your products. So the law ups the ante on that business owner.
Okay.
So you first have to establish what's the relationship between the person who was injured and the premises owner, whether it's a business or a friend or family member.
That will
something like
determine the duty that's necessary.
Yes.
Or in that relationship.
Yeah, that relationship determines the duty.
Okay.
And then once you've established the duty, then you have to, evaluate the facts of what happened, and what caused that person to trip or slip and fall. And then, what are the injuries and so on.
Right.
Yeah.
Okay. So we want to make sure we establish the duty. There has to be a violation of that duty. And as a direct violation of that duty, there were injuries that were caused. Is that correct? And
that's the progressive, the progression of things that you have to establish in these cases.
Okay.
And, a lot of times it can be difficult to establish those because you're on the outside looking in. When I say you, I mean our firm, the attorney and the client. We don't know what the store owner did or didn't do. Now in this day and age, a lot of the retail establishments have closed circuit television.
Right.
So there's a lot of other things that can come into play that can help us establish really what happened.
Right.
And, that's why it's really important that if you do suffer an injury, it's to call an attorney as soon as possible.
Right.
So that we could send out the letters and ask for all of the appropriate information that could be the only way that you can prove your case.
Right.
Yeah.
So oftentimes the viewer might be thinking of a letter as a letter you might send or you get from a relative. But in the legal sense, we call that a spoliation letter. And what are the benefits and drawbacks or the problems if you don't send a spoliation letter early in the process?
Yeah, well, if you don't send a spoliation letter, then you're probably going to lose vital information that could help you prove your case. That means, like, let's say they do have closed circuit television and did capture the event.
Right.
Yeah, and it did capture the event. If you don't send a spoliation letter, you're probably not going to get that CCTV video that could prove your case, because businesses, they aren't required to keep the videotape or the however they store their footage. They're not required to keep it forever.
Right.
And most businesses, they kind of cycle through, every 3 to 5 days or even up to 30 days.
Right.
They purge their tapes, so they are.
Well, yeah, now it's all digital now oftentimes, so they've got to clear up the memory for the new tape.
And so it's gone.
Right. Forever.
And, now, if you send a spoliation letter, what that does is it tells the business, hey, you have some responsibilities now, legal responsibilities, because if you get that spoliation letter, and in that letter we tell them, if you have CCTV video or any type of electronic capture of what happened, or any evidence of what happened, because even stores might take pictures and things like that, or there might be some kind of report that was prepared. So we ask for all of that, but what the letter says, and it advises them that if you get rid of that, then you are potentially setting yourself up for basically a court down the line saying, that's an admission of guilt,
Right.
so to speak.
Right.
Yeah.
Okay. Yeah.
Just getting rid of that evidence can be used against you and inferring that
Whatever was on there
you're guilty.
was not in your favor.
yes.
Yeah.
Yeah.
Okay.
So that's a very, very important piece of this puzzle, putting the puzzle together.
Well, if you've been injured in a slip and fall recently, call a slip and fall lawyer like Stein Whatley Astorino immediately. Get that process started. Matt, one of the other issues that come up is the idea of what if the person that fell had some liability or some fault in the accident? What is the state of the law in Kentucky on situations like that, and does that person still have a viable claim?
Yeah, and that's again a sliding scale, depends upon the circumstances, but typically in a trip and fall or slip and fall case, there is the potential of the injured party having some responsibility for what happened. Again, it goes back to when you're a little kid and you hear your parents constantly tell you, watch where you're going.
Right.
Because the law itself does put that duty. It is a legal duty for everybody to kind of watch where you're going in a general sense. So yes, the law can and sometimes does put a percentage of the injury on the person who got injured. And in Kentucky, it's the law. It's called comparative fault. And what it is that, you've got to think of the fault as 100%. And the person who tripped could be 20% at fault, and then the business 80% at fault.
Or, in addition,
or vice versa.
Right. And if there's multiple, sometimes there's third parties, vendors, things like that are also there for the benefit of the business.
Yep.
That maybe the business owner and the vendor created a condition that caused it.
The more parties that are involved in the event, the incident, then you still, it's a 100%. It's like, a piece of the pie. So how much of the pie was this person responsible for versus this person or this business?
Can you tell the viewer why that's important?
Well,
from their perspective.
From the
injured party.
Yeah, the injured party's perspective is, even if let's say the business is 50% responsible for causing the fall, which then caused you to get injured, they're 50% responsible for your damages.
Right.
So, and sometimes, trip and fall cases, we've had many, trip and fall cases, we've had many trip and fall clients over the years, and their injuries are significant.
Right.
Yeah. It's incredible. It still is. It's always been something. It's an incredible understanding of the injuries that, some of these injuries just from a trip or slip and fall, they're worse than car wrecks. They're life-changing. So let's say you have someone who gets one of these serious injuries. Their damages can be, in the high six figures or more. And, 50% of that is a significant number.
Right. Yeah. So, for example, if somebody had a broken arm that required surgery and had $100,000 in medical bills, and they also had treatment after that, and they were out of work, and their claim was worth $300,000. Even if they were 50% liable for their own injury, that's still $150,000.
Yeah, that's a significant.
Which can be helpful for that injured party in recovery in the family.
Well, one thing I like to remind people is, when, would $150,000 change your life? Of course it would.
Right.
It would change any person's life. That's a lot of money. That's still a lot of money.
Yeah. No, I agree.
Yeah.
For sure. So Matt, earlier you talked about the importance of reaching out to an attorney early in the process for preservation of potential evidence. Can you also talk about other time limitations that exist on slip and fall cases in Kentucky?
Yeah, the statute of limitations, that's a hard deadline that the law establishes within which to either settle your claim or file a lawsuit in court to preserve your legal rights. And slip and fall cases, it's 1 year.
Okay.
It's 1 year from the injury.
And it's also important, I think, to remind the viewer that that means you have to file your claim in court within that 1 year. But also, if you're going to be reaching out to an attorney to evaluate the claim, oftentimes it takes a significant amount of time for us just to put people on notice, investigate, get medical records, all those sort of things. So don't wait till the last minute.
No,
just
don't wait
because
till
you
the
have
last
a year to file doesn't mean you should wait 11 months or even 6 months.
Yeah, that's true. I mean, the sooner the better. I mean, I'm dealing right now with a premises liability claim, and it's taking us. It's a letter writing campaign that involves state government and a state university trying to find out who the paving contractor was for a parking lot.
Right.
And you have to go through
A maze.
state government, and a maze of open records requests, and then they just send you. It's like from one agency to the next. And if somebody came in even 2 months before the end of the statute, 10 months after the injury, we would have no shot at finding out who is actually responsible.
Right. Okay. That's
Yeah.
very important.
Yeah, very important. Probably the most important thing is the timing. If you have a serious injury, you should contact an attorney immediately.
So we kind of talked about comparative fault, time limitations. We've also talked about duties that are owed. Let's move on to the next part, which is compensation. What if an injured party is injured in a slip and fall at a business? What types of items and things can they get recovery for?
Yeah, well, all medical expenses. If you have a serious injury that's going to require future medical treatment, you can also get compensated for future medical expenses. Lost income and future lost income. Let's say the injury is the type that limits your ability to walk, and your job requires you to walk. You're a maintenance person,
Right.
or whatever, you have to be on your feet all day long, and after the injury you're not able to be on your feet all day long. Well,
That's going to impact your future earnings.
it's going to sometimes, in some cases, it's going to eliminate your future earnings.
Right.
Because other factors of age, education, work experience, all those different facts come into play, and it could render a person totally disabled.
Right.
Someone who you can still feed yourself and use the restroom and do all that kind of stuff, but you can't earn an income like you used to.
Right.
And that's very worrisome. Now you can be compensated for that. And then the one thing that everybody basically is drawn to is pain and suffering. That's also something you'd be compensated for. If your injury is expected to cause symptoms of pain, tightness, limitation of range of motion, things like that, then you can also get future pain and suffering. So there are several different categories of loss that you can be compensated for.
Right. Okay. Well, good.
Yeah.
Flip side, what are some of the challenges and defenses that are commonly used by insurance companies that are defending businesses themselves for slip and fall cases? You kind of alluded to some of those earlier. Can you go into more depth about that?
Yeah, it again depends on the circumstances, but one that's a potential defense is let's say somebody is in a store or in an area in the store that they're not supposed to be. Maybe they got lost, or maybe they were looking for the restroom, but they actually were back in the storeroom, or the employee lounge.
Right.
Being in a place that you're not supposed to be, that can be a problem. Not necessarily a complete defense, but it could be a defense.
Yeah, so if you're trespassing at a store.
Well, yeah, certainly if you're trespassing. Right. I mean, for instance, if you are on somebody's land, like you go into somebody's backyard and you're not invited to be in that backyard, and you fall in a hole and get hurt, then that's on you. Right. Most likely. You could be considered a trespasser. But again, there's lots of different circumstances that are involved in those. But trespassing, almost 100% is a defense.
Okay.
Yeah.
So trespassing is one defense.
Lack of, like we talked about earlier, lack of an opportunity of for the business owner to discover the problem. Now, again, like we talked about, the discovery rule, it doesn't really apply if someone who works for the store caused the problem.
Right.
If you cause the problem and you're an employee, then that's on the business.
Okay.
Yeah. But then you can get into some other technical defenses, like if the hazardous condition was snow and ice, naturally occurring hazards, snow, ice, a slick or wet concrete or surface caused by, let's say it's raining really hard outside, and your customers that keep coming into the store, although they're wiping their feet on the mat, they're still bringing water into the store.
Right.
So again, that's those naturally occurring conditions. Although these slip and fall cases, they have back and forth conditions. Like as soon as you introduce a new fact, then it kind of can bounce. It's like a tennis match. Then it can kind of bounce into the other direction. So, people coming from the outside, it's raining outside, and there's the business put down a floor mat to absorb the water and everything from people, but they don't change the floor mat.
Right.
And it's been raining all day, and the floor mat is soaking wet.
Right.
That's that can't. And then somebody who steps off that floor mat, who they thought, as you're walking through the front vestibule, they see the floor mat, and you start to think, okay, well, I can dry my feet off and I'll be okay on this tile floor.
Right.
And then as soon as they hit the tile floor, boom, they're on their rear end and they've broken their leg. And it's like, well, we put down this mat. That's what the businesses say.
Right.
That's reasonable. Well, what more do we have to do?
Yeah, so they foresaw that there was a potential problem here, but they did not follow up with any sort of maintenance.
No, and they just put the floor mat down, and 8 hours later, it's soaking wet, and because the person who got injured fell, let's say, these have actually happened, and they fell, and when they landed partially on the mat, they were getting soaked by the water that was on the mat.
Right.
And so was it the water from outside? Yeah, but the person's feet didn't get dry when they step on the soaking wet mat, and as soon as the very first step they took on the tile, the terrazzo, marble terrazzo floor, boom, they're up in the air. So, again, there are those kind of back and forths.
Okay. Well, can you tell the viewer, maybe give the viewer some points on what you should do if you've been injured in a slip and fall in Kentucky?
Yeah. Now, it's that's a tricky question. I mean, because if you're laying on the floor and you've broken your leg and some of these, again, like we said, some of these injuries are the equivalent of a high-speed, high-impact type of injury like you get in a car wreck.
Right.
So you're probably not going to be thinking straight about anything, much less, I need to get pictures while my bone is sticking out of my leg.
Right.
No, you want to get treatment. You want to immediately, you want medical treatment. Don't ever deny medical treatment at the scene. Don't ever say, oh, no, I'm okay, and try to walk it off. I mean, just, suck it up and get the help that you need. And not only for your health and welfare, but also to document the claim.
Right.
So, call 911, call for people at the store to help you, and then they should be documenting what's going on.
Right.
And they will help you document any witnesses, any information from witnesses, and help you document, what it was potentially that caused you to fall.
Right.
So even the store people, through the years, most reputable store owners, they assist in that process. But if somebody's with you, take pictures.
Right.
Have the person take pictures.
What's important as far as the objects of your pictures? I say a lot of people just go ahead and take pictures of the injuries, but what else would be important and helpful in these types of claims?
What it was that caused you to trip or slip, and have that person get names of people that witnessed.
Right.
That's a really good start.
Okay.
Yeah.
Okay. Well, I think that's all we have for today. I appreciate you guys listening. Matt, thank you for giving us some information that you've acquired over years of doing trip and fall cases in Kentucky. John Whatley, Matt Stein with Stein Whatley Astorino, Louisville's slip and fall lawyers. If you have any questions, reach out to us. If you've been injured, call us 502-553-4750. Stein Whatley Attorneys, serious results.